Iowans are very sure they want to maintain their freedom, and that's including freedom in the courts.
And Justice Wiggins, how do you, he hasn't lived up to what he was supposed to be doing, if that's your...
Well, he was one of the 7 judges who voiced the decision, the Barnum decision on the folks of Iowa, but beyond that, it was a decision that shouldn't have happened ever in the courts. It was a legislative decision. And so the people of Iowa, I think it was really just a straw that broke the camel's back, but they said, this won't stand. And they spoke very clearly in 2010 when the nation said it was impossible. They ousted 3 judges, and he is just the 4th. This is not personal, it's just that he is number 4 and he's up this year. We only get that vote as a people every 8 years. So it's instrumental that Iowans pay attention as they have and be engaged as they were in 2010 in this process. But even more, Judge Wiggins, by his own peers, 63% approval. That is a D- when we're talking report cards. This is by his bar association, people who will be in front of his bench possibly, and they felt the need to say only 63% approval rating.
And yet they're going to follow you around the state defending him.
Isn't that interesting? I think that's a question we're all waiting to hear their answer on. I think it's the attorney, the bar association that pride themselves in being so self-regulating, and yet here they've openly got this example we all see, 63% D-, and yet they're going to defend him.
Why go after Justice Wiggins when, as you said, the decision is legislative? Taking him off the bench won't change the decision, and it won't change it for the future, this particular issue. Is it a worry about future decisions he might make, or how?
Well, first off, this is the year that the people have the opportunity to vote on the justices every 8 years, only every 8 years. That is quite a span of time. And so this is the process that the Iowa Bar Association put in place decades ago for just this reason. When the Iowa people feel that there has been a mistake, that there has been a wrong, and this certainly was a wrong, on the freedoms and the liberties and the separation of powers. So that's why you see this campaign taking place, to guard our liberties, to guard that separation of powers, that protection in place.
Will, after this particular retention election, the next one that comes up with the other justices, will there be another campaign?
If those justices remain on the bench, I am hopeful that the Iowans will again engage in the process. It is vigilant. Our founding fathers said we will have liberty if we guard our liberty. And if we don't stand strong on our liberties that we've already lost through decisions like this that should have never happened in the courts, we don't have to worry about those liberties we're yet to lose.
Will you also be lobbying the legislature?
Well, right now, I think we're focused on this November election. Like I said, this is the voice the Iowa Bar Association gave the people of Iowa in 1962. I think it was their plan for Iowans to have this vote. This is the only voice of the Iowa people in the judicial branch. Judges don't rule at the pleasure of special interest groups and PACs. They rule at the will of the people. This is the will of the people.
The Bar Association is saying by going after Justice Wiggins, you're making it political, like you're trying to let future judges know that if they don't go along with your beliefs, that their jobs will be in jeopardy. What is your response to that?
First off, let's be clear. This isn't about what I think or what you think. This is what the Constitution says. And this judge overstepped his bounds along with the other 6. And this is totally just justify or maintaining that freedom in the courts. And again, let's come back. The Iowa Bar Association set this process in place so that Iowa people would have a vote. This is the only voice of the Iowa people according to the Iowa Bar Association. And so for them now to act like they're surprised or offended or that Iowans should not participate, to want to disenfranchise the Iowa people in having a say, I find stunning.
When you look back at the decision, and it was a unanimous decision, they say that that is strong evidence that they were voting and they were interpreting the Constitution, and they were all, that the fact that they were all agreeing with it, the fact that it was a unanimous decision indicates that they were going along with the Constitution, that they were interpreting it correctly. How do you feel about that?
Well, first off, you have to go back to the separation of powers. Jefferson talks about the courts being nothing but an oligarchy and the Constitution a thing of wax if we leave it just to the judicial system. Secondly, Alexander Hamilton, I believe it was, in the Federalist Papers, said if it affects the body politic, a large group of people, it belongs in the legislature. Courts are for individual remedy. This should have never been in the courts. And let me give you an example right here in Iowa. September 2008, there was a court case, and I think the defendant's name was Isaac, and it was a sexual assault case, a sexual offender. And the courts overruled several previous rulings that he was not guilty because under Iowa code, current Iowa code, there wasn't the specific victim or whatever their interpretation was. But here's the difference. Instead of saying, and now we're making the code say this so this doesn't happen again, they said we have no other way, our hands are tied, but to release him and send model legislation to the legislature to fix if they wish. That's the difference. In this case, they didn't send anything to the legislature. They didn't turn it back to the legislature. They didn't offer model legislation. They took it in their own hands on the court's bench where they did not have the authority. They do not make law. And that's the difference from September 2008 to April 2009.